Hi, my name is Nurdin Zulkifli Suhaimi and my matric number is 1082. So, I will explain about compulsory winding up. A company can be legally forced to wind up by a court order. So, how about the asset inheritors? In such a case, the company is ordered to appoint a liquidator to manage the sale of asset and distribution of the proceeds to creditors. The court order is often triggered by a suit brought by the company creditors under Section 464 of the Companies Act 2016. The competitors may include the company, the creditors, a contributory, the liquidator, or the official receiver, or the registrar of companies. Once the order has been made, the High Court appoints the official receiver (OR) as liquidator. The official receiver works for the insolvency service and find out how and why an individual became bankrupt or a company went into compulsory liquidation. So what is involved in compulsory winding up? So all the company's contract, including employees' contract, are complete, transferred or ended. The company case to do business, outstanding legal dispute are settled, all the company's assets are sold, any money owed to the companies is collected, and any fund are distributed to creditors. Surplus fund, after the repayment of all debt and share capital, can distribute to shareholder.
Hi, Assalamualaikum. My name is Muhammad Haziq bin Haris. My matric number is 01DAT22F1049. Okay, I will present voluntary winding up. The word voluntary is used to describe this kind of winding up. A voluntary winding up may be either a member's voluntary winding up or a creditor's voluntary winding up. Under the Companies Act 2016, there are two types of voluntary winding up, which is the members voluntary winding up and the creditor voluntary winding up. Both types of voluntary winding up involve the appointment of a liquidator to oversee the winding up process, but do not require the same level involvement as in a compulsory winding up. Members voluntary winding up. A member voluntary winding up, the company must be solvent. The commencement date of this process is date the member pass a resolution to initiate the winding up of the company. To confirm the solvency of the company, the director may issue a written declaration stating that they have made an inquiry into the company's affairs and have formed the opinion that it will be capable of settling its debts for the next 12 months following the start of the winding up. Any director making a declaration without reasonable grounds for the opinion that the company can meet its debts commit an offence. Creditors voluntary winding up. If creditors voluntary winding up is initiated, the company must arrange for a meeting of its creditor to be convened on the same day or the following day on which the resolution for voluntary winding up is proposed. The notices of the meeting of creditors should be sent by post to the creditor concurrently with the notice of the meeting of the company proposing the voluntary winding up. Final meeting post voluntary winding up. Once the company affairs are fully wound up, the liquidator is required to prepare an account detailing how the winding up process has been conducted and the disposition of the company property. Following this, the liquidator may convene a final meeting of the company's member, or in the case of a creditor voluntary winding up, a final meeting of both member and creditor. The account prepared by the liquidator shall serve the purpose of providing explanation during the final meeting. Lastly, conclusion. Closing down a company in Malaysia require careful consideration of legal, financial and strategic factor. The article highlight the options: member voluntary winding up, creditor winding up and striking off, each suit to different business scenario. Striking off is suitable for a dormant company, while winding up addresses more complex situations with creditor and assets. Okay, thank you.
The difference between compulsory winding up and voluntary winding up is compulsory winding up is ordered by the court, while voluntary winding up is initiated by the company. One process is decided by directors and shareholders of the company and is usually in their best interest. The other process is forced upon businesses that fail to pay their debts to creditors and is very hard to reverse. That's all. Thank you.